Hello, I'm Rick Steele, and I serve as the chair of the Licensed Psychology Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic media. Bruce Nystrom.
Here.
Jonna Norton. Abby Callis. Carol Crane. Jessica Hamilton.
I thought Jessica was in the meeting earlier. She might have logged off, and I'll see if she logs back in.
Okay. Tiffany Johnson.
Here.
Janine Kesterson.
Here.
Rodney McNeil.
Here.
Zachary Parrott.
Present.
Doug Wright.
Here.
And Rick, Jessica Hamilton just logged back into the Zoom meeting.
Great. I note the following staff members are also present: David Fye and Leslie Allen.
Here.
Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director of the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at the meeting today, as no individuals requested to provide public comment. Because we're conducting this meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to the meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we'll be conducting this meeting pursuant to the KOMA. On February 16th, 2022, we sent notice of the advisory committee meeting to all individuals who requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice on the website, and also an agenda and other meeting materials were posted to the board's website as well. You may request a copy of the agenda by sending an email to david.fye@ks.gov with a subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allows the members of the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. But as we are after hours currently, it would be best to go ahead and send an email to document those issues by sending an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda.
The meeting is now called to order, and the advisory committee will begin with its discussion of the first item on the agenda, which I believe is the approval of the agenda. I believe all of you received that on Monday. Do we have a motion to approve the agenda?
This is Doug. I move we approve the agenda.
Is there a second?
This is Jessica. I'll second it.
Okay, all in favor, please indicate by raising your hand.
Yes.
Thank you. Okay, so the next item on the agenda is the minutes approval from our meeting on February 8th of earlier this year. It was sent in the same email as the agenda for tonight. Hopefully you had a chance to look at that. Were there any comments or corrections? Do I have a motion to approve the minutes from February 8th?
This is Tip. Approve the February 8th minute, or move to approve the February 8th minutes.
Is there a second?
Second.
Thank you, Bruce. Any discussion? All in favor of approving the minutes, please indicate so. Okay, it looks like that. Any opposed? Okay, I believe that passed. Okay, so I think our next agenda item then, having to split our back between two pages, is Executive Director's report.
Thank you, Rick. I'll go ahead and provide some updates on BSRB operations, some legislative updates, and then also some updates from the last board meeting on March 14th, 2022. So the office of the BSRB is still under most of the governor's pandemic directions. Through most of the pandemic, we've been able to keep the office open, but there were times where the governor directed staff to work remotely. Since about January, we've had most of the office here every day. We are still continuing to do that while two investigators are doing a little bit of work through a telework project we had approved by the Department of Administration. So we are collecting information and looking to expand that potentially as we go forward. We are still under the governor's direction to limit or avoid having in-person meetings, which is why all of the board meetings and advisory committee meetings are still being done virtually. And we will keep you updated on if that direction changes and we're able to go back to having in-person meetings. In terms of some legislative updates, the legislature is currently on a 3-week break from their action. They're supposed to be coming back in about 2 weeks to do a period called omnibus, which is when they come back and consider any bills that were vetoed by the governor. They get updated revenue information. They get an estimate for all required human service caseload spending. And then they go ahead and sometimes pass a trailer budget bill. Sometimes they also do a tax bill, but in general, it's a lot of the cleanup work they do before this legislative session ends. So they are on pace to come back. Before they left for this break, they did pass a number of bills, and I'll give you an update on some of the items that are relevant to the BSRB. In terms of the budget for the agency, the overall state budget was put into House substitute for Senate Bill 267. The House earlier and the Senate passed different budget bills and then went to conference committee and worked out the items of difference between the two. And they were able to pass a budget bill before they left for omnibus. And so that bill was presented to the governor on April 8th, 2022, and is currently pending with the governor's office. In terms of the other items relevant to the BSRB, earlier this year, the BSRB requested introduction of a bill which had 3 recommendations that were forwarded from the board. The 3 recommendations concerned a recommendation for the social work profession. There was a recommendation for the addiction counseling profession. And then there was a recommendation from your advisory committee that had to do with requiring continuing education hours for licensed psychologists in the area of diversity, equity, and inclusion. And that bill was Senate Bill 387. The last time your advisory committee met, I believe it was the day before the hearing of that bill in committee. That bill was heard in the Senate Public Health and Welfare Committee, and the committee scheduled a day just for that bill to be heard. And I testified in support of the recommendations of the board. There were 3 other individuals who submitted written only testimony that were also supportive of the bill. No one asked to testify in opposition or neutral testimony. At the hearing, I was the only speaker in person, and the committee did ask me a number of questions. I think probably it'd be fair to say they asked me about 30 questions concerning the content in the bill, and I would say that probably 25 of those focused on the recommendation involving the licensed psychology profession. They asked me some questions concerning sort of the origin of the recommendation, and I did my best to summarize the history of how that recommendation became part of the bill. I noted the other groups that had requested introduction of language to require continuing education and diversity, equity, and inclusion. I noted the groups that were supportive of that, from the Kansas Psychological Association, the national associations. I mentioned the work that was being done in other states. I received some questions about, what would it mean to have diversity, equity, and inclusion required training or education? There were some questions on some different speakers talked about possible origins of some of those terms. Some of the other members of the legislature on that committee asked why this was being required and why not other topics such as suicide prevention training. Others questioned the availability of training, if it would be required, if there would be enough options. Some members of the legislature asked questions about, would it be too limiting in terms of what other individuals were able to take for continuing education? And some asked if it would be too burdensome on licensees that might be choosing between Kansas and another state, and would it make them potentially choose another state instead of being licensed in Kansas? And so I did my best to answer those questions, reflecting the conversations that were had in this committee, also the conversations that were had by the board. I can tell you that the overall sentiment of that committee was not in favor of that item. So the committee did not work the bill the same day. They came back shortly after and went ahead and worked the bill. They made a recommendation to remove the licensed psychology recommendation from the bill, and then they kept the other two items in the bill without any changes. And then they moved that amended bill out of committee favorably for passage. After that time, there was a certain legislative deadline for bills coming from committees to be worked on the Senate floor. I was advocating for the BSRB bill to move forward, and they did not work it. And so essentially Senate Bill 387 died. Under normal circumstances, we would not be able to have a bill in this year. But I went ahead and had a number of conversations with different members of the legislature and was able to have the amended version of Senate Bill 387, the version that passed favorably out of the committee. I was able to have that contents introduced on the House side as House Bill 2734 and expedited for a hearing in the House Health and Human Services Committee. That committee went ahead and had the hearing, and in the same day they worked the bill. They passed it out of committee, and then they passed it on the House floor. So it passed one chamber. There were no more opportunities for it to be heard in the Senate committee, but because it passed one chamber, it was eligible for the contents to be included in other bills during conference committee. And so that's what happened. Essentially, when bills are passed in two different forms, the legislature will go to conference committee to resolve the items of difference. And at that time, they can make adjustments or amendments or add in new language. And so there was a bill, Senate Bill 453, and in conference committee, the members of the House and the Senate Health Committees agreed to move the contents of House Bill 2734 into Senate Bill 453. So the amended version of the bill that was 2734 moved into Senate Bill 453. And that bill was put back before the House and the Senate floor, and it did pass. And so that bill has now been submitted to the governor as well, and it is waiting for the governor to take action. If the governor signs the bill, it will go into law. If the governor takes no action, after 10 days, it will go into law. And if the governor vetoes it, then it will come back before the legislature when they return. I think it is likely, based on the margins that it passed, that the bill will go into effect, and I think the governor will sign it probably any day now. So that is where the BSRB bill is at currently. In terms of another bill that was relevant to the agency and the work of the advisory committees, there was a bill earlier this year. It was known as sub for Senate Bill 34, and it had a couple different versions of it, but the final version would require all agencies to provide a report to the Joint Committee on Rules and Regulation every 5 years on all of their regulations, and they would have to indicate whether each regulation was essential to requirements of state law. And if they were not essential to a function of state law, then they should be revoked. And it included an expedited revocation period for those regulations. The bill was included ultimately in House Bill 2087, and it was passed and it was forwarded to the governor for review. Based on the position of the board earlier this year at a special meeting, the board had asked me to present testimony expressing concerns the board had in opposition to being included in that bill, because we are doing our due diligence at going through our regulations and statutes. We're moving appropriate changes forward. And so we had requested to be exempt from the provisions of that bill, but that bill did make an effort to include all agencies. And so we were included along with the other agencies in that. So we are waiting to see what the governor's action will be on that bill as well. In terms of some updates from the board meeting on March 14th, 2022, the board indicated that as long as we will have board meetings that are going to be online, the board preferred to go ahead and have those start at 9 a.m. instead of 10 a.m. So the board meetings going forward for the regular board meetings will begin at 9 a.m., starting with the May board meeting. Additionally, we did a lot of work last fall on a document called the Board Governance Policy. And I created a report to assist the work of the board with highlighting some recommended changes or some items for the board to discuss to determine if they wanted to keep those items in the policy. We also have an investigation policy that guides the work of the Complaint Review Committee, as the board also has the responsibility to investigate complaints and reports of alleged violation of statutes and regulation. That investigation policy has not been updated since about 2009, so it is definitely due to be updated to match the current work of the CRC. So I am in the process of putting together a report with the assistance of legal counsel and also the investigators for the board, and I'll have that ready for the board at the May meeting so they can review potential changes to that policy. Additionally, we are doing some cleanup work in terms of the statutes and regulations of the board. Frequently in the statutes and regulations, the text of those statutes and regulations references the board. And in some of those instances, it does mean the full board will make a certain decision. In other situations, it refers to an action that has been deferred to the BSRB to act on behalf of the board. And in some instances, it mentions the executive director responsibility that has been deferred to the executive director. Other times it could mean a different entity, such as the Complaint Review Committee or potentially advisory committees. And so as a way to provide more clarity, we're going through the statutes and regulations and bringing to the board instances of those references to try to really clarify when it says the board, does it mean the full board or does it mean another body? And then if there needs to be a renewal of delegation motions, we can take care of that and have that all squared away. Additionally, the board at the last meeting discussed there are two professions that have board-approved supervisors, the professional counselors in marriage and family therapy. And there was a discussion of whether there were sufficient opportunities for board-approved supervisor trainings. And so if we are requiring this as part of the requirements for the supervision process, can the board have any influence in making sure there are sufficient trainings? And if there are not, what actions should the board take? And so the board had an initial discussion about this, and this will probably be something that will continue at a discussion at future board meetings. On another note, I was recently offered to serve in a position in a commission for the Scipac Commission on one of their committees. As you might recall, Kansas became a member in the Scipac Commission as of January 1st of this year. And I was asked if I would like to serve on an elections committee for that group. I brought this issue to the board because this was the first of the associations we work with that had offered me a position to serve. And before I accepted that or considered it, I wanted to know the board's perspective on, would you like me to bring those before the board, or how would you like me to handle those opportunities when they are presented? So the board had a discussion, and they basically advised me to use my best judgment when I'm provided those opportunities. Of course, my first priority should be the work of the board. And so if anything is offered that would endanger that, not to take those opportunities, but otherwise accepting some of those could be helpful for the board in other ways. And so I did not accept that position. I went ahead and declined that for now so I could focus on other matters. But in the future, I will keep you updated if I get other offers to sit on those committees. And then the board also identified a couple of topics for future discussion. The first is that in other states and some of the other agencies in Kansas, they use a program that is referred to as an impaired provider program. When certain individuals who are licensed have issues with substance abuse, or in some situations need mental health services, some of those states or some of those other agencies have programs set up where it can be sort of an alternative to some of the disciplinary action, to have the individual voluntarily receive treatment through those programs. So that is something the board is going to be discussing in the future in terms of if it would be appropriate for Kansas to look into maybe using one of those programs. And additionally, the board is going to be discussing an approach to telehealth, excuse me. The board is going to be discussing an approach to telehealth standards. We've been talking about the rules of unprofessional conduct. And one of the topics that ties into that is the unprofessional or the telehealth standards for the professions. So the board might go ahead and have a conversation on that topic in more detail at future meetings to try to see if, as much as possible, the standards could be uniform between the professions, though there was conversation that there are certain differences between the professions, at least as far as testing and assessments. So that is something for the board to discuss in the future. So with that said, I'll go ahead and end my report and I can answer any questions.
Thank you, David. Were there any questions or comments about anything in that report? I don't really guess I'm certain that the Kansas Psychological Association is aware that the DEI provision was removed from that bill. At some point, we might want to, I don't know, I guess we don't need to visit with them, but if we were going to revisit that topic, we might want to consider how we would do that in a way that would be, I don't know if the word is more palatable to the legislature, if that's the right term. Part of me wonders if it was a timing issue. David, if I recall correctly, there were some committee members who had perhaps linked the diversity, equity, inclusion issue with critical race theory in that committee meeting. And at the time that was, that in certain legislatures across the country, that could be a problem. I don't know how else to say that. So maybe we'll revisit how we could consider that. Rodney, were you about to make a comment?
No, actually, I was trying not to make a comment.
Okay, well, I'll support you in whatever you decide to do there.
I thought it wise.
Okay.
Now, I did mention there were 3 other individuals that were provided written only testimony in support of the bill, and I think at least 2, if not all 3 of those, were members of the KPA. And I did communicate with them after the Senate body did make the recommendation to remove that from the bill. And so once that was removed, that really, it wasn't a good opportunity to go ahead and have it move forward, at least not this session. But I do know that, the social work profession, they had a survey in December, and one of the questions they asked their licensees was, would they be supportive of requiring continuing education in the area of diversity, equity, inclusion? And I believe the majority of social workers did support that being a recommendation. So, so there is some support from other professions, but for that to be included in the continuing education requirements, it would need to go through a bill passage. And so that is going to be a challenge, I think, for the issues that I cited earlier. So.
Yeah. Okay. I think it might be, I mean, we have a year, almost a year to think through that. One of the things in various discussions that occurred to me was, I don't know that we articulated as well as we could have that some of because I remember that the committee may have also wondered why we weren't proposing specific education or continuing education requirements for service members at risk for suicide also. And maybe if we could make it clearer that the DEI would assist with that, right? That there may be some areas of overlap, but who knows? Other comments about the director's report? So I think the next item is an update on Scipac. And you touched on that a little bit, but I think you have maybe more specifics on that.
Yes. So I think at each one of these advisory committee meetings, I'll just give you an update as we have more members who have submitted to practice under the authority of Scipac and list Kansas as their home state. As you might recall, that is how individuals are able to practice under the compact. So licensed psychologists are not automatically under Scipac. They actually have to apply to the Scipac Commission, and they do track it by what home state those practitioners have. And so I did reach out at the beginning of April, and I asked for a current count. They indicated to me that as of the beginning of April, there are 40 individuals which hold an authority to practice interjurisdictional telepsychology, or is also called an APIT. And that's the one that allows them to practice teleservices in other compact states. So there's 40 of those in Kansas, and then there are 4 who hold a temporary authorization to practice, or a TAP. I can tell you that we have started to receive some phone calls here in the office from individuals in other states that are currently licensed in Kansas, and some individuals are weighing whether or not to go ahead and renew their license in Kansas or to let it lapse and practice under the Scipac Commission. And so we will be keeping an eye on the numbers for our licensee totals, and we'll give you an update. All licensed psychologists do renew their license in June of even numbered years, so that is coming up. So we're doing our best to provide information to individuals when they call. Also on the BSRB website, there is a link where individuals can find out more information on Scipac. There's also a link to a portal. So if you are someone from the public who's receiving services from someone who claims to be from Scipac, you can actually look them up to verify that they are a Scipac practitioner. So that is a way that individuals can check, and also for our investigators to check to see, if someone receives a complaint and someone alleges they're practicing without a license, we can also check the portal to verify if they're practicing under Scipac. In your materials, I included the most recent Scipac newsletter. These do come out quarterly, and one of the items that is included in this report has to do with the most prevalent individuals practicing in Scipac by state. So just as a quick rundown, Pennsylvania has the most members currently, followed by Texas, Illinois, Maryland, and then Virginia. But there are still a number of states that are not part of the compact, but I believe it is probably about half of the states that are in, or just a little over half at this point. It does break it down by quarter in terms of the new members that are practicing under Scipac by state. So you can review that information if you'd like to take a look at some of that information there. But otherwise, I don't really have anything new to provide under Scipac, just a quick update on the numbers there.
Okay, thanks, David. So the next item on the agenda, any questions about Scipac from anybody? Okay. The next item on the agenda is our discussion of the unprofessional conduct regulation, KAR 102-1-10A. This was our homework. Hopefully you remember that you had homework. So we were asked to look at this regulation to determine whether it needed to be updated in any way, whether anything needed to be added or clarified. I don't necessarily think that this is a one session question, so we can start and we can do some considering. I've thought about different ways to structure this. One would be just to go through A through, I think, P provisions. The other would be to go more conceptually or things that we can look to see if maybe someone had an idea if that's addressed. Thoughts about how we want to launch into this?
I thought it might be easiest to start with the record keeping part since it's just a one pager and then launch into
Okay.
the other side, just so we could feel like we accomplished something.
So we could do something. Okay. So record keeping,
Yeah.
see, that is,
And Rick, I just wanted to mention on that point, last time I provided a copy at your last meeting, it was just the regular unprofessional conduct regulations, but yeah, there was that separate one on unprofessional conduct record keeping, which was 102-1-20. So that's also in your
okay, yeah,
materials.
sure. So we can, yeah, Doug, we can absolutely start there with, 102-1-20. Let me pull that up. Okay. So shall we just, what are people's thoughts?
One of my thoughts on record keeping is always that, we have our regulations, but I think a lot of us are also guided by different insurance companies and third-party administrators on what kind of records we need to maintain. And I dare say that we may pay more attention to that because that's attached to dollars that we either earn or don't earn.
True.
True.
And along those lines, we work under KDAD so much here at this agency, and these rules for psychologists are much more lenient in terms of how long we have to retain records. It's only 5 years, whereas KDAD's is 10 years. I don't know if we want to just leave it this way and know that we're going to go with the most stringent, or if we want to try to make a match, but there may be different rules for different people depending on who they work under and the type of work they do.
I tend to agree with Doug. I feel like if we are, well, I guess I shouldn't say I agree, but I think that, for individuals who are practicing, in private practice and things like that, maintaining this, even though it may not be the same across, I don't think we're going to be effective in making a standard that is going to be the same across entities at different levels, whether that, you know what I mean? So I think when I read through this, I think that it seems reasonable as far as time frame goes. I don't necessarily think that extending things out farther is going to, or making it more conservative is going to help or change outcomes really. So I kind of like the idea of just leaving it as it is, unless anybody's had a problem with it.
And are you specifically talking about the length of time?
Sorry, I muted myself. Yeah, I was referring to like the length of time.
Okay.
And just a matter of clarification, these regulations are currently active and on the books, right? We're discussing potential updates, but this is actually the wording of what is
This is it.
in action.
Yep.
Okay, thank you.
One thing I will talk about in terms of this specific regulation, one of the other advisory committees that met last week did mention that if someone is trying to find the rules of unprofessional conduct, it may not be intuitive to look to two different regulations. And they questioned whether there should be a separate one for record keeping or whether this should be a continuation of the original regulation. So that advisory committee actually recommended combining them. Now they're also looking at it as this is not a one-stop review, that they're going to continue to work on these throughout the year, but that is something they had discussions on. So I was curious what your committee's thought would be on that as well.
For what it's worth, I think combining them makes sense. The unprofessional conduct regulation is one of my favorite ones these days, because it gets me out of a number of things that lawyers will try to get me to do with respect to providing them directly computerized testing materials. So having it all in one place would be lovely.
I agree with Rodney. I think it'd be a great idea to combine them. Our goal is to protect the public, and it seems making these type of things a little more user friendly or intuitive would be an easy low hanging fruit we could probably accomplish.
That makes sense to me. I'm looking at, I'm curious, David, or maybe Leslie Allen, why does anybody have a history on why record keeping was pulled out? I mean, it's alluded to in paragraph M in the unprofessional conduct, but it just says CKAR 102-1-20. Is there, again, I'm agreeing with Rodney and Doug, but I'm just curious on what the rationale for pulling it out to be special might have been. Is anybody have do we have a legal historian amongst us?
No, I don't know. It was before me.
Yeah, and the only thing I can add on this is that it's not that it came around after the last revision to the unprofessional conduct regulations, because the record keeping was last updated in 2002, and the unprofessional conduct was last updated in 2004. So, so I'm honestly not sure why it's in a separate one right now.
Okay.
It's the square ham again.
Along those same lines, I can't come up with a compelling reason to separate them, much less put them back together again. That goes with your question, why were they separated in the first place?
Right, because I was trying to think about why would someone separate it, and it can't be for ease of adjusting, right? So if there was a policy, that was, but it wouldn't require any more or less work to change 102-1-10A than it would to change 102-1-20. So that can't be it. So,
Well, Rick, I don't know if we can
Can
do
I-
this real time, but it would seem logical that the way to get at that would be to look at those changes that were recorded. If you could go backwards in time, I don't know if we keep those, like what we put in a new piece of regulation, and what the old looked like before it was modified. But that would be one way of kind of looking at it. Because I wonder whether or not this started out as kind of a baby thing and someone started expanding on it.
yeah. Jessica, what were you going to say?
I was just wondering, so with the record keeping, a lot of times, at least in our health system, especially since what is that program called, where basically all of our notes are being seen by the patients now?
Mm-hmm.
With record keeping, I know that some of my mentors in the past for psychodiagnostic or neuropsych testing, that they would put their time record keeping information as far as the testing goes in the EMR, but they wouldn't necessarily put a full report in the EMR because it's shared across, and they wanted that in a sensitive note. Is there anything to this record keeping stuff that is related to that aspect of it being able to be separate, or does it make sense to just combine it? I think this is getting back to like, what is the point of having this separate?
Might want to remember that these were last reviewed in the days prior to EMR. So these were not written in how to work it with EMR at all.
And maybe relatedly, is there any other statute or rules of action here that references the record keeping document that then would not find it suitable for it to be subsumed under the dash 10A?
That's a good question, Zach.
Yeah.
Yeah, let me.
Yes, I'm familiar with the rest of them, but yeah.
So I've pulled up the BSRB page that lists all of the regs. And that's, I think that's a good way of thinking about it. But again, if there was a reference to the record keeping in something else, like, I don't know, in one of the other regulations, it wouldn't be more difficult to refer to it inside unprofessional conduct, right? Because it would you just add or maybe I'm not thinking of it correctly. So.
I think so. I mean, it's just like setting up pointers.
Yeah.
Because basically you're asking what references this particular act. And if you put a new pointer in that says, instead of pointing here to point to the original, I think that would fix it. But that's a brilliant point.
Yeah.
You could actually cause a mess if you just were to willy-nilly get rid of it.
Yeah, so now I'm looking at at those. And so 116 is use of computerized psychological tests. And if I'm not opening it, but if I remember correctly, it points at me being responsible for all of the content, even if I'm using computerized equipment. There's parts of that could be unprofessional conduct too, right? Yeah, what a mess.
Well, I think we've identified one of these bigger conceptual things that I think, mentioned earlier. Maybe we should just go back to like specific content within the document and see how we all feel about that. And then maybe, David, could you possibly identify where some of this stuff originated from to help us answer the question at the next meeting?
You mean in terms of the history of these regulations?
Yes.
Yeah, just in terms of, well, is there a reason not to pull it back in under unprofessional conduct?
Okay.
I don't know who, I agree with Jessica. I don't know who would answer that question specifically, but there's got to be someone who would. Yeah.
Okay.
Well,
yeah, I'll look into that and bring back some information.
And I don't know if this will be useful, because I don't want to put too many monkeys on David's back. Knowing what references this particular statute, is there an easy way to figure that out? Like an indexing, I don't know if that exists.
So it's not a tool that I have access to, but I could ask one of the legislative services and see if they're able to pull that for me. Sometimes they can help me out with some of that background information. So I'll reach out and see if they can tell me what else highlights that or references that regulation.
I think that might be useful.
That might be fun to see. Okay, so I think Jessica had a really good suggestion so we're going to work on whether it can get moved back or into unprofessional conduct. But in terms of the actual content of the record keeping, sounds like we're okay with the length of time that the records are to be kept. I didn't hear any thoughts about that or any suggestion to change that. The content that's specified in the regulation, it sounds like people are we comfortable with the content, or is there anything that either EHR or telehealth have brought to us in the last 20 years that would change what we would need to document? So we've got identifying data, dates of services, types of services, initial assessment, conclusions, recommendations, the plan, clinical notes, and detail to permit continuity of care.
I mean, I think the only thing that I could think of that we could add, which I don't know if it's 100% necessary, is like where it took place. But I mean, most people are already documenting that anyways.
So whether, and by where you mean, did it happen in this office or did it happen over the internet?
Yeah, over telehealth.
I'm assuming that billing records are also considered as part of the record keeping process, correct?
Well, if we're taking a strict reading of the regulation, I don't see billing listed in 1 through 7.
But there is something in here about I thought an accurate record of when you met with the person. I thought I read that.
Well,
Is
the
it good?
date, with the date, yeah, 2 is the date or dates of services, right?
Right, which could be found in the billing record.
It could be.
Yeah.
But it doesn't, this regulation, as I read it, doesn't require me to keep billing records.
No, but it goes to this question about where something took place.
Oh, okay.
Because in order to bill for a telehealth service, I have to add a billing modifier that actually communicates to the insurance firm where this service took place, or how it took place. But where may be another question.
So would that be number 3, the type or types of services?
I think it may be different.
Okay.
That's pretty broad,
Yeah.
Tiffany. I agree with you because that, I mean, does that mean I did assessment or treatment or consultation?
Yeah.
Or does that mean I did telehealth?
Right.
Right. And it doesn't say.
I think it's difficult to make an adjustment on this now because I think the standards are still evolving. If you look for American Telemedicine Association as a guide, they would recommend that you do document in that note, whether it was telehealth. They also recommend that you're documenting in that note if there are any interruptions. So I do think it's a standard of care, but it might be more detailed than we need in this regulation, because there's lots of standards of care that are different for different types of work that we do, and that detail rarely, I think, is seen at this level. So I'm not sure we have to include it here, because I think it's a standard of care issue that will be evolved over the next several years.
Okay, let me jump in here for a split second here, because I was just thinking about a conversation I had with an individual who worked for an insurance company that provides telehealth services, and about a battle she got into with a client who did not want to disclose where she was. And they have a requirement that has to be documented in the record in the event that there's an emergency situation and they have to direct emergency services to her. So I'm wondering, is there something absent here in light of telehealth that we may need to clarify more clearly, like something like that might need to show up in the record as a matter of standards? But I'll throw that out there.
I think it's a good point. I'm kind of torn on how to respond. I think possibly, but I also see that as, because we have at our agency, we've developed a policy related to identifying where they're at as a part of risk management. And which I think is what you're kind of referencing, Rodney. And
Exactly.
I think that's incredibly important. I guess what we have to look at is, do we feel like that's a minimum or a required standard for documentation, or is that a policy-based issue? I certainly think it's a risk management issue. I think you're spot on with knowing where that client is. I think it might be creating a standard that is difficult. If I play that all the way forward, and let's say a client tells me I'm at my aunt's house, and so is that good enough, or do I have to document a physical address? I think it starts to create other problems. And then how do we enforce that standard if the client is untruthful with us, which happens, so I don't want to create a gotcha situation where we create a standard people can't follow.
Right. Well, in this case, it was even more kind of tricky because the individual was working. She was a home health care person, and she didn't want to disclose where she was at because she was actually at her employer's house, would have been in violation of HIPAA. So it was a little bit even more dicey. But we do mandate that people as a standard of care. I don't know, maybe it's not, that you assess for suicidality and homicidality, HI and SI, during your encounters. Maybe this is part of that. I don't know, but I do agree with you.
But what about the provider documenting where they were?
That goes to what I was saying earlier about the billing record. You have to tell them, that's kind of where you're telling them where you are when you provide that service. And most times it's a two-digit code that says either you're in your office or you were somewhere else. But that's passed on to the insurance company as part of your claim.
And it's not included in the state regs of what you document right here.
Right. Right. But should it? I mean, I see the point.
Yeah, that's a good.
I guess, does the provider location, would that affect client care? Because our duties to protect the public,
Right.
would documenting our location or not documenting our location, either way, would it affect the public? Does it create a new or different risk if we document it or we don't document it? I think is something to consider.
I wonder if not, because I was thinking, well, really what matters is where the patient is, where the client is. And so that's when we get into issues of you practicing, potentially practicing outside of your licensed area. And that's much more important, I would think, as opposed to where I am. I don't know, maybe you need those two pieces.
No, I agree. I agree with you, Rodney. I think that that's probably better handled in another area besides record duty. Because when I think of that, I start thinking about scope of practice and other regs versus just record keeping. I agree that it's an important factor because we need to have something somewhere that really addresses, we can't be practicing outside of our licensed area unless with Scipac, but some regulatory oversight of us. So I agree fundamentally. I'm not sure that in our record requirement that would help us there.
So not to add a whole lot to this, earlier in the year, maybe it was last year, we had a conversation about disposition of records in case I die. And the board kind of, we talked about that at the board for, I don't know, a couple of sessions, I think. I'm not remembering that we came up with did David, am I just forgetting, or did we resolve that?
It was kind of put on hold.
Okay.
Yeah, so there was general support for having essentially some new language for that topic. Excuse me. But our previous understanding was that the Attorney General's office would seize the records. We'd be able to work with them in cases where the records were abandoned in most situations. And then as we started moving closer towards implementing something, we learned that they would only really seize records if they were in danger of someone else getting them. So if they already had someone like a spouse who had them, even though that may not be the most appropriate custodian for them, they wouldn't seize them in that situation. And often they wouldn't assist with getting the records transferred over. It was more of better for the records to be destroyed than from someone improper to get access to them. And so it really made things much more complicated in terms of how we could coordinate efforts. So that all kind of reached ahead right before the session started. So we kind of just said, let's go ahead and pause this and then approach it after this session ends this year. So
I wonder if a low-tech solution is just to maybe even to add to this regulation for us, just a little D in there that the psychologist is responsible for identifying, a receiver of records. It seems like it's leaving it up to the psychologist, but it's also making it clear in our code or in our regulations, as it is in APA's ethics code, that something will be done with those. Because as far as I can tell, the state of Kansas is silent on this at the moment.
Now, Rick, I wonder, the other part of that is, yes, you can do that, but how would the person really needs to know that, which is the patient, know
Right.
that? And should that be something that is part of a standard informed consent form?
Well, that's how the conversation with the board went. We did talk about that we talked about a number of things, including psychologists or mental health providers identifying at the time of licensure who the records would go to at the time, if they're in a practice where that makes sense, right? So if I kick over, all my records still live at the University of Kansas and they'll be there forever, right? If I'm at, Children's Mercy, same thing is true. But if I'm seeing private patients, that I would identify to the board who the custodian of those records would be. And that way, theoretically, if I drop over and one of my clients calls the board and says, hey, my psychologist is dead, where's my records? They would be able to find my most recent license renewal and say, oh, you should check with, whoever.
Okay.
But we didn't get there. That's not where we are yet. But that would require an update of a different regulation and changing the forms.
Conceptually, I like that idea that they could contact the board, and hopefully all disciplines, not just psychologists, would have that information with the board. I think that's beyond our scope, which is kind of what you're saying, Rick. But I do like your idea of adding a note here that says psychologists are required to make arrangements for their records.
And it seems like those two things would be compatible, right? If we decided that there was a little letter D down there that said something to the effect of, providers, the failure of the psychologist to identify a it could copy some of the language from little letter A, failure of the psychologist to identify a receiver of records upon their death or incapacitation shall constitute unprofessional conduct. that,
Assuming they're not dead.
well, right, once they're dead, it's not really a problem anymore because they're,
Well, it is a problem, but but you don't have anybody.
not for me, not for Rodney. Once I'm dead, I'm not worried about it. But the failure to identify is something that I can be something that someone could address with me today, right? So once I'm dead, there's nothing you can do, as far as I know, Rodney, unless you have powers beyond what I am aware.
Not yet this week.
But once I'm gone, right? But you could regulate if I have failed to identify someone who will be the receiver of my records. So that if a client were to ask, hey, if you, that would be an odd conversation, wouldn't it?
Mm,
Mhm.
indeed.
Oh. Anyway, just an idea. We don't have to decide this today. Just that's a, any other, what else? What other thoughts do we have? Do we need to bring 20 to a close? Have we done some good work?
I think that my consensus is we're not changing this. That's my walk away. Did I miss something?
It sounds like we're mostly happy with this.
Oh, okay. I just want to make sure I didn't miss it.
David, do you feel like if the legislature were concerned about us not reviewing records, do you think we've done a good enough job of ferreting out the ins and outs of this that we could, with good conscience, say that we have striven to update our regulations?
I think so. Yeah. Their main concerns with other agencies were that they just don't review them in a long time, and there's things that should have been changed that are not, and so.
And I think that's fair, right? I mean, we always joke about in Lawrence, there's a city statute that requires you to honk your horn as you're entering the city limits so that you don't scare the buggies. And it's still on the books. And so next time you're driving into the fair city of Lawrence, make sure you honk your horn so that you don't scare the buggies. That's probably not been updated in a couple hundred years. So what's your pleasure? Do you want to wrap that up? And I don't know that. Go ahead, Doug.
I was going to say, do we just need a motion then to leave 1021-20 the same?
I think if there's really no action, there's really no need for a motion. I think in the minutes, we would just probably say that there was no specific recommendation for changes to that at this time. So,
perfect.
There was considerable attention given to them, and that the wisdom of the advisory committee was that there were no changes necessary. Okay.
Yeah, I think after the unprofessional conduct, the other items on the agenda are relatively short. So I think there would still be time if you wanted to take a look at the main unprofessional conduct regulations or start to get into those today.
Okay. Let's do this. There's A through P. I don't actually know what number P is there's a bunch of them. Let's just start with A and just kind of look at it and see if, would it help if I put it on my screen, or for people like having, what would be easiest for people's eyeballs?
I think we have it.
Okay. Okay, so A is practicing psychology in an incompetent manner, which shall include the following. And that includes misrepresenting professional competency by offering service to perform services that are inconsistent with training, education, or experience. performing the services that are inconsistent with those, and then failing to provide psychological services that the licensee is required to provide under the terms of a contract. They're obviously written pretty broadly. Okay. Well, we can move on to practicing with impaired judgment or objectivity. Basically, we've got substances, and then we've got our own mental health or personal problems. Someone's going to say something because I keep worrying that my screen is freezing.
I'm following you, Rick. I'm not seeing any huge changes yet.
Okay.
And Rick, I'll let you know too. I did ask our two investigators if any of these items they wanted to comment on as well.
Yeah.
They do have a couple comments a little bit later as we go through the list. So I'll point those out when we get to them. So.
Okay.
One of my issues, I spent a lot of time reading these on the CRC, and just the way the document is typed and spaced, I think it can be retyped in a way that shows a much clearer outline form and make it easier to move around the document and read to see what's under what and all this. And that has nothing to do with revising anything, just make it easier to read.
I agree with you, Bruce. The starting with the little letters and then going to the big numbers and then going to the big letters makes me just nuts. But I think that we may be stuck with that.
So that's legislative type. Isn't it,
Yeah,
David?
it's awful.
Yeah, it's a legislative style.
Since we're not legislators, can we put it in psychology style?
We could submit it that way, but it would be changed in the editing process, unfortunately.
Although,
A full year of law school just to learn how to do it.
although I think Bruce has a good point there, and I don't think it would be a bad thing to have almost like a patient's bill of rights. That would be, because this, if I were a consumer, this is hard to read. I mean, this is just, when I cover this in my ethics class, I mean, their little eyes just kind of glaze over. It's terrible. And so I have a color coded one, and that I use in there. But if I think Bruce is right, even if it was just reversed so that these are the things that, but that's not for us to fix today. Okay, dual relationships. That's number C.
Yeah, one of the investigators did have a comment on C.
Okay.
So on C, it says, engaging in harmful dual relationships, which shall include the following acts. And then number 1, making sexual advances towards or engaging in physical intimacies or sexual activities with either of the following: any person who is a client or any person that the licensee knows who has a significant relationship with the client, supervisee, or student. And I guess they wondered, looking at the language of big A and big B, B indicates that it says any person that the licensee knows who has a significant relationship with the client, supervisee, or student, but A only makes reference to client as opposed to also including supervisee or student. And kind of they questioned if that should also be included in A or if it should not. So
It has an or statement attached to it. So it
Right.
looks like a gate to me.
Okay, so I always have to work this out, right? So if I make sexual advances towards a client, or if I make sexual advances toward
Student.
anyone who has a significant relationship with a client, with the client, which I think refers back to the one in A.
Or student.
Yeah, but so, right. So I'm not allowed, I'm engaging in a harmful practice if I'm making sexual advances to someone who has a relationship with a student, but I can make sexual advances toward the student.
I don't think so. I thought there were three groups it was just covering: the client, people the client knows, and students. If you touch any of those people, you're engaging in unprofessional conduct. That's my read of this.
I agree that's the intent, but I think if you read it and break it down the way Rick was describing, I don't know that's.
It's murky at best.
I almost feel like A should say, basically you can't have intimacies with a client, supervisee, or student. And then B should be separate. And
Right.
it is also
Right.
impermissible to have sexual intimacies with a significant other of a client.
With my student's mother.
Right.
Much clearer, much clearer. I agree.
So to David's point, we would probably, we obviously need to have legal counsel. Because as far as I know, none of us are attorneys. If you are, just jump right in there. You're an attorney.
I am an attorney, but I don't work as an attorney for the board. So
Okay, you're not our attorney. So we need our attorney. I would support adding supervisee or student up there to A as well, and then leave B just like it is. So that means I'm not allowed to make sexual advances towards my client, my student, or my supervisee, or my client's sister, my student's mother, or my supervisee's aunt.
Is that forever? Not that I'm asking for myself. I just want to put that out there. But is there a time component to this?
Drop down and read paragraph D, parenthesize G. And these two regulations we're talking about here contradict each other.
Okay.
There needs to be some resolution on that, because the first one we're talking about now just says, well, no sex with anyone who's a client. But then the next one says, no sex with anyone who's been a client within the past 2 years. So that, and on the complaint review committee, it's not been quite this bad, but we've had people say, well, I did a termination report Friday afternoon. We went out Friday night and had sex, and that's okay. And they're just reading that one section. Okay. If they read on down a few more sentences, they'll find out that's not true.
and also under D, that section also just references a client. The investigators asked if section D, that basically says making sexual advances towards or engaging in physical intimacies or sexual activities with or exercising undue influence any person who within the last 24 months has been a client. The investigators asked if that should also include supervisee or student, or if it should just be limited to client.
I would think that it needs to be expanded.
I agree.
I can't think.
Include everyone under A. Yeah.
Yeah.
I can't think of a reason not to, right?
I can tell you lots of reasons I've heard in CRC.
Are any of them good?
Any good reasons, correct?
Yeah, okay, so let me retract that statement. No good reasons not to include. Ugh. Okay.
Does the 24-month time period, does that still seem like it's a standard for the licensed psychology profession? I'm not familiar with the the National Association standard if they commented on that time period.
That matches the APA FX guidelines, right?
Yeah, it does.
Yeah.
Unless it's changed.
Because this is about power, the perception of how much power the psychologist may have over the individual and for how long that power might exist. So I think 2 years. Some of my attorney friends, I'm just amazed. We actually have something. I think they can actually sleep with their clients. And I found that very interesting.
Well, okay, so maybe we expand D as well. So not to leave C too quickly, we got through 1A and B. Then there's the 2 and 3. 3 is very, very broad, just exercising undue influence. And then 2 is financial interests.
How do you define 3?
It might be in the definition regulation. If you give me a sec, I'll look for that.
Okay. Like, I'd like to know if I'm being undue influential.
I can think of ways that I don't know that I can contain the universe of ways that would happen, but I can imagine if you were running for city council and were using your influence in your office to get people to vote for you.
Oh, gotcha.
Or if you, I'm that's the first place I went.
Yeah. Or giving cost breaks to patients who agree to help with your campaign.
Sure.
Yeah, I see that now.
So I would think it would just, it's obviously pretty broad, and I guess at some level it's kind of user defined, right? If I'm your client and I feel like you have had undue influence over me, it's my job to present that to the board, the CRC. Leslie, did you find something?
Yeah, sorry, hold on. It's in the definition regulation 102-1-1. Do you want me to show it or read it?
Or just read it.
Undue influence means misusing one's professional position of confidence, trust, or authority over a client or supervisee, or taking advantage of a client's vulnerability, weakness, infirmity, or distress for either of the following purposes. 1, to improperly influence or change a client's or supervisee's actions or decisions, or 2, to exploit a client or supervisee for the financial gain, personal gratification, or advantage of the psychologist or a third party.
Got it.
Can you read 1 again under that you just read, Leslie?
1,
Yeah.
to improperly influence or change a client or supervisee's actions or decisions.
Okay, the improperly. Because I was thinking all that we do is try to influence their actions and decisions. We're out of a job. Okay, improperly. Okay.
David, it doesn't sound like that part had, the investigators didn't identify.
No, I just have those 2 comments that I'd already mentioned. And so, yeah.
And Bruce, from your perspective on the CRC, you haven't seen anything that is tricky on the CRC related to finances or undue influence?
We've had some financial complaints, and I think some of these came under that. We had a therapist at one point who hired active patients to remodel their home, and he didn't like the remodel job he did. And so he refused to write a positive report back to their probation officer.
Wow.
I mean, yeah, so.
That seems latent.
Yeah, there's always creativity involved there.
Okay, so it sounds like the regulation was helpful and clear in that, so, all right.
I don't want to go too far afield, but I know when I discuss this with students, typically I make distinctions between what it's like if you're in the city, particularly with the dual relationship thing, and when you work in more rural areas where you may not necessarily have access to other people that you may be providing services to.
Yeah,
I mean, has there been any squawking for folks who are in rural side of things that they really want to practice ethically, but the reality is there's only so many of certain types of individuals around. I'm thinking about a friend of mine who was actually in a rural place, and she actually was being seen by a psychiatrist that she actually referred to as well. But he was the only one around.
it sounds like it's not a harmful relationship then, right?
Hopefully.
Right.
Worked in small towns, those things come up a lot, and what you do is try to eliminate all sources of dual influence and cross purposes and all this and that. And you can do it. You can do it, but it gets into trouble when someone just doesn't pay attention to the fact that they're seeing the car dealer in therapy, and they went and bought a car, and the car dealer gave them a really good bargain.
Mm-hmm.
I mean, the APA ethics code would certainly say dual relationships don't have to be eliminated. We have to manage those because it is impossible in rural areas. You can be a psychologist working in a mental health center, and you're the soccer coach at the rec, and guess what? One of your clients gets put on your team. You don't select your team, the rec center or whoever selects the team. So how do you handle that? Because then you're in that question of what's doing more harm. You can't break their confidentiality as to why they shouldn't be on your team. Is it more harmful to move that kid? And those are real world examples. And I think a psychologist just has to use consultation in those times and come up what's in the best interest of the client.
Okay. Are we up for a few more?
I actually do, if it's okay to bring it back. And my pause comes from a licensure complaint against a licensee, not within our state, but of the supervisee definition. So are there different, and should we delineate different levels of supervision? The example I'm bringing forward for y'all to consider was a clinic manager who was not direct supervisor of the trainee, but then so was supervised by some other clinician who was then supervised by this clinic manager, and they began a relationship. Clinic manager, trainee, and there was concern there. So is that worth putting forth more some delineation into that? It's treacherous, no doubt about it.
Yeah, I think it's a good point that you raise, because often when we talk about supervisor, we're thinking clinical supervisor, perhaps. But then there's, like you say, in any work environment, there's multiple layers. And so what does that mean? So I'm the COO of my organization. So I guess in broad sense, you could say I have some supervisory authority over every clinician, correct?
At least perceived, right.
Yeah. So, so what would that mean for me if I were single, which I'm not, but what would that mean? Could I never date anybody that worked here? Or I don't know, it's an interesting topic. I hadn't really thought about it in those terms. I'm glad you raised the question.
I would think in that situation, what would inform my thinking would be more about risk management, not ethical code. Because one of the problems with being in a position of authority and dating someone under you is you open yourself up for for all kinds of lawsuit if the relationship goes bad. You know, then the person makes allegations against you that suggest that you used your position to actually get have undue influence over them.
So you're sort of suggesting, Rodney, then those would be separate things, that our regs are really about using our, I don't know, clinical influence versus something that's administrative or work related.
Yeah, I would think so. Because again, when I heard you say that, I immediately went to the risk management side of myself, going, oh, I would never want that to happen because lawsuit and dealing with employees and all that stuff. Plus,
Right.
I've actually dealt with a guy who did what you're talking about. It didn't end well.
Yeah, I think there is a whole nother avenue for protecting people from that type of influence in terms of employment law. You're right.
But it
And
is,
I guess maybe to make my point, the question pointed is the use of the word supervisee, is that definitive enough, descriptive enough for someone, for licensee to say, okay, I read this and I'm making my decision based on that because it's very specific for me, or is it worth more clarification? I guess I would ask.
Zach, I don't know if this gets at what you're asking, so please tell me. I guess it boils down to me is, you know, do you have power that is quantifiable over an individual? Right. And if you don't, then we're fine.
well, Rodney,
that's probably up to perspective, right?
Yeah.
On initial decisions versus kind of later on burden of proof, evidence bringing type of things. Yeah.
but is it also not only just power, but it's your power in your role as a psychologist, right? Because a person could have power in a situation in which they're not the psychologist, right? And so to Doug's point, so he's the COO and he is a psychologist. When he's doing his COO stuff, is he a psychologist?
And thus
Maybe
under
that's
these regulations.
right. And that maybe that's splitting hairs too much. But
No. I would argue that in what you're saying about Doug, it would be more his ability to hire and fire that really garners him the power that he exercises. It has nothing to do with the fact that he's a psychologist. That just happens to be a hat that he's wearing when he's doing his nefarious deeds.
or not.
Or
right?
not.
I mean,
Yeah,
or
yeah.
not, right?
Yeah.
I mean, he may not be wearing the psychologist hat when he's doing his nefarious deeds.
Yeah.
Shame on you, Doug.
How did I get to be the example?
Because you threw in the COO thing. So I don't know, Zach, how to answer your question.
Supervision is defined as well.
Oh, well, there we go.
Supervision means the formal relationship between the supervisor and supervisee that promotes the development of responsibility, skill, knowledge, appropriate attitudes, appropriate attitudes and ethical standards in the practice of psychology. Supervision shall include both general training supervision and individual clinical supervision.
So a person who's managing a clinic and you happen to be an employee in that clinic, that's not necessarily what was described in that definition.
No, I wonder if the mixed area is that you're acting as a role model of professional conduct for psychology and your role with that individual. That's kind of what I heard.
Yeah.
I'm going to have to jump off this call. I got some conflicts emergent. So
Okay.
talk to you all next time. Thanks.
All right. Thanks, Bruce. Okay.
No, I think we all probably would, at face value, we understand when we see supervisor, supervisee, we think of the direct combined relationship of clinical provider, clinical trainee. Like we understand that. And then it's the systems that we work within that then put us in different levels of hierarchy beyond that. So I just thought it, and we don't have to change anything by any means, but if nothing else, a good time to think about where our professional regulations are pointing to, where we're trying to stay, within what box we're trying to stay in, and if our very specific box needs to be further defined, or if this feels like this says exactly what we think for it to say when it comes to supervision.
Does this part of unprofessional behavior get acted upon, David, all that often? Well, I don't know if you know this when it comes to, or maybe even Rick, when it comes to complaints, do we have that show up a lot?
I'm not sure that we keep those kind of records in terms of the frequency, but those two comments especially came from the investigators when I asked them to look through and just identify things that you think the committee would want to look at and possibly evaluate changes. So
yeah, I'm just kind of get to Zach's question about delineating more. Is this a problem needing a solution? That's what I'm wondering.
Rodney, I'm great at finding problems that have no solutions or don't need one.
A government job may be waiting for you.
I work for the VA. Yeah.
Oh, there you are. You found a home.
yeah, and I think in terms of that, the one under C, I do think at least for that one, it does seem a little strange, and it would probably provide some clarity, given that B references client, supervisee, and student, but A only references client. And so I think on that one, it could resolve some, lack of clarity if it referenced all three in A as well as B. But
Yeah. Okay. David, could I ask what additional items the investigators pointed to as particularly problematic, or
those were the ones that I
That's
had
all?
from them initially. So I don't have any additionally one tonight. I could ask them to take a further look and help identify some other ones for future conversations. But and I could ask them, based on what they have seen, are there any of these that have become the focus of a lot of complaints or something like that too, if you'd like me to. So
I suspect that number E, informed consent, is probably not real high up there on.
Let me ask you this, Rick. So again, I'm applying this to some of the stuff that I do, where the person that I'm working with often isn't the patient or the client, it's the court. Is there still a mandate, and I do it anyway, that you do have to get informed consent, and is it viewed as assenting?
Can you ask the question again?
Okay, so if you have someone who's being compelled by an external force to come see you,
Okay.
They are not the patient. The person who's compelling them to come is the patient. So do I have to get informed consent with this individual who's being compelled because they're not my patient?
Rodney, I don't know if it's required, but how we handle that at our agency is we have our normal informed consent, and then we have what we call forensic informed consent. And so that forensic informed consent, we're informing the client that they are in fact not our client, and that what they share with us is going to go to the court,
Yep.
and that they have access to those records. And so our agency, I don't know, 15, maybe 20 years ago, developed that just because we felt like it was important to clarify for the client so that they knew whatever they were going to share in that assessment, who had access to that. We felt like there was still an obligation to inform them that they didn't have complete control of their record as they would in a normal setting. So that's how we handled it. Whether that's statutory, I can't tell you.
We do pretty much the same. We do our general informed consent, and if you come in for a court-ordered assessment, there's a separate forensic form that enumerates two central points. One, the issue of who the real patient is, and two, affirming their autonomy, that you can stop anytime you want. And I don't work for the court, by the way, you know. So we've taken that approach. I think that's more of a just, it seems to me like an ethical thing to do as a psychologist. Whether or not it's truly in the ethical code, I think it is appropriate to let these people know.
And I wonder along that point if we need to add something along that line here.
I'm wondering if that, do you think that goes in here, or is that in the records?
It would be in record keeping, I would think. Or, well, you could do it two ways. I mean, it could be under this informed consent aspect that you would have to codify a little bit more what informed consent would look like.
I think it might make more sense here now that I think about it. I originally had written down a little note as you were talking that, oh, we need to go back to the documentation. But this isn't so much about documentation. This is about ensuring the client's privacy. Even if you can't protect their confidentiality in that particular moment, you can protect their, protect their privacy by letting them know whatever you share with me is going up the river. So if there was a number 4 under here is failing to inform clients or patients when, I don't know, information, or maybe, hold on, let me look just a second.
Yeah, because Rick, you could put it there, or you could put it under making
under G, right? Failing to protect confidentiality. Well,
Okay.
look at G2, Rodney.
Okay.
Scroll down on your page. Scroll down to G2.
I've lost G. Oh my gosh, where is it?
It's hidden. It's right underneath big 11 on the second page.
Okay, thank you. Big 11. Oh, got it. Reviewing information regarding the claim or failing to protect information. Okay. I'm not still thinking in my case, we're talking about the same thing. Remember, they are not my client. So I would think it'd be more about misrepresentations than an issue of not disclosing their information because they're my client.
I absolutely understand what you're saying, but I'm also wondering if, let's say that I am compelled to go see you by the court. And if I feel like you have done something wrong, I'm going to not Doug, you're not on the, no, I'm going to, who am I going to? Bruce. I'm going to Bruce on the complaint review committee. Are they, what you're saying about technically Rick's not my client is court. And yet I'm going to bring an allegation against you to the CRC and they're going to investigate it.
Okay, welcome to my world, Rick, because that's exactly what happens.
Yeah.
And often that's the argument I have to put forth is you are not my patient. And what is clear is they didn't like a position I came up with. So they couldn't win in the courtroom. So now they're going to take it to the BSRB.
Right.
And that happens.
Mm-hmm.
And I think the other piece is outside of the possible complaints that they may bring to the board is I think we should have an obligation to inform them what's going to happen with that information. I think clients come in with an assumption about confidentiality, which simply isn't true in that forensic arena.
Oh, yeah, yeah.
And I think we should have an obligation to inform them of that.
Okay, so you're putting it squarely in E under informed consent. And so you're suggesting adding 4, right? That it is failing to obtain informed consent includes failing to inform clients or patients as defined here. When I don't know, when confidentiality, or because that's what it's getting at, is you're failing to inform me theoretically.
I think it's a failure to inform the patient of the limits of their relationship with you.
And the requirements imposed by other, right?
Yeah, something along that line. Because they need to know that you actually don't have a relationship with me. That's fundamentally what's going on there.
So maybe it's including to inform clients when a third party is defined legally as the client. Sounds wordy, but that's the concept, right?
That's the concept, right?
Leslie, can you look up patient and client in the definition regulation? I'm just wondering how the state is going to see this. I get what you're saying, and I don't disagree with you. I'm just wondering.
Client or patient means a person who meets either of the following criteria. 1 is a recipient of direct psychological services within a relationship that is initiated either by mutual consent of the person and psychologist or according to law. Or 2 is a recipient of psychological assessment or diagnosis for a third party.
I think they're your clients and your patients, even though you don't, according to the law. I get what you're saying and I completely understand, but I think the state of Kansas says that they're your patient.
Yeah, and that's a conflict there for me, because patient implies that you have rights in this context, which you do not.
Yeah. But I think the spirit of what you're saying, we can absolutely fix here, right? Because so everyone here understands what you mean by saying they're not my client. Got it.
Right.
State of Kansas says they are. They deserve some rights. You're wanting to make sure that the patient or client understands when your ability to maintain privacy confidentiality is compromised by a third party. Right? Is that what you're?
Oh, yeah. I think you need to disclose that.
Yeah.
Up front.
Yeah. David, I see you're taking notes. Is any of this making sense?
Yeah, I think so.
Okay, good.
Yeah. I realize this is going to be kind of a longer conversation to go through all of these. And so
yeah, it's going to be terrible.
And I think, the ultimate goal is at least for my ultimate goal, by the end of this year, if we can have some good changes to these, some updating, some good recommendations, and this might mean having conversations today and then having more at the next meeting. And so you don't specifically need to make recommendations on these items tonight, but
right.
I'm keeping notes so that you can revisit these conversations next meeting, or so.
Okay, so next, I'm going to go ahead and call it for tonight, because my brain is starting to feel a little mushy. Let's plan on the next time we meet getting through J. Does that sound reasonable?
Sounds good.
Okay. Because there's a handful of other little thingies on the agenda that we should probably at least mention. And I'm having to change screens to see what those thingies are. Okay. Okay, so possible requirements for assessments or services to be performed in person. Is this a holdover from did we talk about this?
This was briefly talked about last week. There was a topic on the agenda for work for the committee this coming year. And one of the comments that was made was, should there be certain assessments or services that should only be performed in person versus over telehealth? So I went ahead and just added this as a follow-up item. You can either consider it for conversation tonight, or it can remain as something for the committee to look at during the rest of the meetings this year. But I didn't want to lose track of that item for you. So.
Okay, I want to put that, if it's okay with the committee, I would like to put that underneath J in the unprofessional conduct discussion. Item J is improperly using assessment procedures, which shall include the following. Right, so since we're talking, does that seem reasonable to have it in that context?
I think so.
Doug's giving me a stare.
Yeah.
I don't know
Yes.
if Doug agrees. He's giving me.
I agree.
They're
I'm
referring.
trying to read two things at once. So yeah, I
Okay.
agree.
There was furrowed brows, and it was.
That could have been the stroke he was promised. So you never know.
I just struggle with like switching between my different. I just switched
I know.
over to the agenda, so I had to find it and then read it. So
Well, I'm
I
on my
agree.
I'm on my little screen tonight, so everything's having to be. It's all squished together. Is that okay, David, if we do that? If
Yep, that makes sense.
Because my concern about delineating a specific number of things that must be done in person is that's going to change, right? And we're not going to be able to update that and so I think there needs to be more of a principle that could fit in that regulation. I think that would make me comfortable.
I completely agree. Some kind of a principle that says we don't conduct assessments via televideo that are inappropriate, because that will change and evolve, because they'll change the technology, and
Right.
who knows, maybe be able to do an assessment tomorrow that by
Exactly.
Yeah.
So today it means I can't do this, and this on telehealth, but those instruments are going to change probably because of what we've all been through the last 2 years, whatever it's been.
Mhm.
Right. And so I think we need to have something that's going to last, so we don't have to do this every, 2 years.
Agreed.
Okay. All right. So I punted on that for us. C, pre-approved providers for continuing education.
Yes, and so I can explain that one a little bit. This was from the last board meeting. At that board meeting, the board discussed for the social work profession, there is currently, we have authority to have pre-approved providers of continuing education courses for social work, continuing education. They had requested that in the past, and in your packet of material, you have a copy of one of the social work regulations. It's 102-2-4B, continuing education approval for sponsors. So for the social work profession, you can have, you can become a pre-approved provider of continuing education courses. And it's something that you apply to the BSRB for. You have to meet certain standards. And then if you do that, you can basically hold yourself out as a pre-approved provider. And if you do that, you can advertise that for your continuing education courses. It is more upfront work for our office to go ahead and review that, as opposed to reviewing each of those continuing education courses on the back end when someone is audited. But it is helpful during the auditing process if we know that certain ones came from a pre-approved provider. There's also a way that individuals can just submit for one course and have that course specifically pre-approved by the BSRB. But it's just for the social work profession. They had requested it in the past, and the board recently discussed, would the other professions like to have something similar for their professions, or would they not? But they asked the advisory committees to have that discussion, and then basically report back on if you would like the BSRB to work on some sort of a write-up for each profession, or is this something that you're not interested in? It's not a requirement. Any continuing education providers are not required to do this for social work. It's just something that they had requested years ago. And so it's something we have for that one profession. So wanted to let your advisory committee have a discussion on that topic to see if you thought it'd be appropriate for the licensed psychology profession.
Rick, you provide continuing education through our program.
Yes.
Okay. I was under the impression that APA requires the course to be approved, not the person providing the course.
No, we're approved, we're an approved provider. And so
Right.
the way that works for the APA approved providers is that, well, I think it's a 5-year approval period. It's kind of like accreditation. You send all your materials in, you have your board, what your quality assurance mechanisms are, examples of what you've done, examples of how you evaluate what you've done, and then they approve you for some period of time. And then I can offer whatever I'm going to offer, and I am an approved provider.
Okay. Okay. So it's the same thing as the social workers. They've got these approved providers. And then once you're approved provider, that was going to be my next question for social workers as well. You can offer anything you want and still give CEUs for it.
Yeah.
For it. It's not by course basis. Huh.
Yeah. So my dogs are about to start getting crazy. So if you hear a weird sound, it's my dogs. Hey, cut it out, guys. The difference is for the social workers, they're having this BSRB pre-approve some courses that may also be, or providers who may also be approved by the NASW, for example. Right? Am I correct, Leslie?
Yes.
Right. And so the assurance then, and it's actually can be beneficial for the providers, for them to say to their constituencies, hey, we're a BSRB approved, right? I can't ever say that. I can say I'm APA approved. And to my knowledge, BSRB has never turned one of our people away for claiming those hours, but they could.
Right. So if we were to do something similar for the psychologists, not that I would do this, do an end run around APA and just go to the BSRB and get certified as an approved provider, and then offer courses at that point and be able to offer authentic CEs. Is that what we're saying?
That's exactly what they're saying. Yeah.
Oh, I like this. Okay.
Because there's no requirement that anyone has APA. I mean, that doesn't really mean anything.
Oh,
right?
okay.
I mean, APA, I mean, so we're an APA approved provider.
Uh-huh.
You know,
Uh-huh.
All right. So, it's some kind of, I guess it's a quality assurance thing. I mean, sure it is, but the state of Kansas doesn't recognize it.
Hey, David, could you charge for an additional fee for that?
Yes, we do. If they want to apply for that. Mhm. Yeah, and Leslie, I don't recall those amounts. I'm sorry to put you on the spot, but
That's okay. An approved provider is the first year it's 100. The second, when you renew it, it's for 3 years and it's 250.
Oh,
And then a single program is 50.
I'm for it.
My concern is it could inadvertently send the message to some erroneously that those are the only people who could provide CE. And so I think it could become a slippery slope. Our job isn't to make the providers look better or make their life easier. It's to protect the public. And I do have that concern that, sometimes when you start saying, oh, you're pre-approved, it sort of begs the question of, well, then if this person's not, should I not go to them? Is there a higher risk? And I think it's hard sometimes to find good CE anyway. I don't want to do anything that limits that.
I think you're right, Doc, because I could see how now I'm going to start looking askance at Rick if he doesn't have this oh, APA, that's nice. But the BSRB is actually my state. So I care what they think.
It's only my program for 79 more days, Rodney. Then it's someone else's problem, and I don't care where you go after that.
Oh, okay.
Although, Doug, on the other hand, I appreciate the way you're asking the question. Leslie, here's another question you may not have the answer to. Just a ballpark percentage of of psychologists who are audited,
Mhm.
what would you guess the number, their percentage of courses that are denied would be for them? Does that make sense? I've lost all my good words for the day.
The the difference with psychologists is that a lot of you do not just do CEUs, you
Oh,
do
right.
many different
Yeah.
preparation, presentation, all these different things. That's why staff is kind of like, every time you come due for renewal. But it's not very high.
Okay.
We don't have a high number of people who don't get their CEs approved.
I was thinking along Doug's line there, so that if you told me that 10% of psychologists turned in hours that didn't count, right? Then that might argue for the need for public protection, right? To say this is a pre-approved one so that we don't have more psychologists turning in hours that can't be approved. But
right,
you're right, we're a squirrely bunch and we turn in all kinds of stuff that we, yeah, I've got my little folder right here ready to turn in because I got my little email the other day.
it's open.
So does it sound like we're not just ready to rush onto that platform yet, or other thoughts?
Well, quick, Alex, the way you asked that question, again, is this a problem that we need to solve?
Well, that's Zach's department, figuring out if it's a problem that has no solution or needs no solution. So I'm going to defer to Zach on that one.
Maybe not, but I can line up 10 people to help you figure out whether you do need a problem or do need a solution.
Well, I don't want Leslie running off to do something that she doesn't have to do. But I think the answer lies in what kind of information she pulls back on the percentage of people that get invalidated credentials or invalidated education hours. Because again, if it's not that small, then this is not a problem. It's not that big. It's not a problem.
We haven't kept track in the past, but we could try, just a ballpark figure when we do the audits this year.
What is the most common thing that people get in trouble for? When it comes to ed hours in general?
Some people just have really strange things that to me would not be psychological in nature. There's just, but I'm not a psychologist, so when I have things like that, I take it to Rick or Bruce. So yeah,
you're literally talking about the topic of the training within the sphere of psychology. Now that's interesting. I would think they would do the thing where they say they've got something because they were intending on taking it after the June turnover, and then they get busted on that.
Yeah, they do that. They renew before they have their CEUs.
Yeah.
And they go to the complaint review committee.
Well, and I sit in on those complaint review committee meetings too. And one of the things that I see is sometimes people will renew early. And there's really no reason for them to renew early except they make sure they get it by the deadline. But then if they renew early, and you're right, they haven't taken all their CEs, then they attest that they have when they really haven't, and that's a violation. So.
Yeah, and then there's that whole question that I always have: if I renew now, and then if I go to a workshop in May, right? That's before my renewal period. Can I count it next time around? No, I don't think so, right? So it's just a wasted workshop.
It is.
Yeah.
Unless you have dual licensure, then you can use it. Yeah.
Oh,
if you got no licensure in Missouri.
really?
Yeah, because they license on an off year.
Oh.
So you get to reuse your ed hours. It's kind of fun that way.
Huh. Okay. So it sounds like we're not ready for an action on this particular item just yet.
I think that's correct.
Okay. that looks like we're down to the new business. There's a discussion of, we're going to punt on the discussion of accreditation standards because that would really do us all in tonight.
Yeah, and that's listed on the agenda as a topic for a future meeting, so.
Yeah, so we're punting on that one for another day. So I think the next item on the agenda is making sure that we have a time in June to meet. Looks like David has Tuesday, the 14th down.
Yeah, I think usually your meetings are on the second Tuesday of the month, and there's off months, and so that would be the second Tuesday.
You know what? I am out of town that day, as it turns out. I think. No, I'm not. I'm back on Monday. I'm back on Monday, the 22nd. I mean, sorry, Monday, the 13th. So I can make the 14th if everyone else can.
I can as well.
Sounds good to me.
Okay. Well, unless there's any other items, I would entertain a motion to adjourn.
I move we adjourn.
I second that motion.
All right. All in favor?
Aye.
Aye. Okay.
Aye.
Okay. Well, thank you all very much. We'll get through some more of the unprofessional conduct, and we'll try to keep Doug out of the hot seat next time. We won't let him be the guinea pig for all of our test cases.
Just every other time.
It'll be my turn. It can be me.
I make no promises. I kind of like Doug.
Well, thank you for your hard work, everyone. I appreciate it.
All right. Thanks, everyone. Good night.
Bye. Night. Bye.